Irene is a professor of law at the Texas A&M University School of Law. She's also affiliated with a number of other universities, an author of several books. We're really just delighted to have Irene here with us and on this very interesting topic.
So first of all, I want to thank you all for the organization and for hosting. It would be wonderful to be in beautiful Salt Lake City now, but unfortunately we can't. I'm actually talking to you from Singapore right now, where I've been since March, when COVID has basically blocked everybody's travel. So I am still in Singapore. So what I have been very interested in doing, I, like many other scholars, share and have shared for years a bit of the concerns about over protection in general in intellectual property. And in the trademark world, across the world, we have seen a rush to trademark everything. One of my latest book is an edited collection on non-traditional trademarks. That's something that deeply concerns me, the overlap between protection of design and copyright and trademark trade dress as a way to chill potential competition because trademark never end. But what I was interested when I start to see COVID is really this, and I'm going to guide you through some of these statistics. Some of really the unprecedented amount of filing. And so I'm now really an empirical scholar. I'm not trained in statistics, but I can count and I can work through the tests, which is the Uspto trademark registry quite well. And so what I've been doing is, and we have been extending that, but at this stage, I want to present to you these findings. We've been looking at application. At this point, most are just application. There is no registration for trademarks or strings of words that include the word COVID, coronavirus, social distancing, 6 feet apart. Now we're also looking at quarantine, shelter in place, and a few others. Very basic methodology. We have been looking at the tests, at the free form, and mostly at standard trademark in the sense of words. So you just, here you can see these are screenshots, just key in the word and then see what the results are. And then one by one, we have been opening every single application and then coding for what type of mark, the date of the application, which register, the serial number, if later there is a registration number, the applicant name, the type of applicant. I'm going to show you the vast majority of either individuals or small businesses, the type of goods and services, and then the class, the international class, the basis for registration based on Lemon Act, actual use, intent to use, or international application, to where we are in the prosecution, because a lot of these will be rejected. So the first non-final office action has already been sent to several, and then whether or not some of these terminology has been disclaimed. And so these data are, when I'm going to submit the article, I'm going to finish up to the end of August, but we are more or less updated till August 13. And so up to August 13, with these 4 strings, we had over almost 400 trademarks. And as of today, we actually have 402 trademarks. So just in a week, we had almost 10 plus trademark coming in. For COVID, 48 for coronavirus, 15 for 6 feet apart, and 50 plus for social distancing. What we have been doing, what I did, I broke down each of these by type of business at the beginning, because I'm very interested to see what type of goods and services are applied. So some, and also depending on the business, there are different issues that come up. So some 30% for the strings that include the word COVID, COVID-19, or related to, but using the word COVID, COVAX, and so on. 35% is actual medical related business. That includes insurance. Then we have 25% that is unrelated business, but actually existing businesses, something like COVID children clothing or COVID Tabasco sauce, things that don't make much business sense, but still there is an existing business that wants to sell these goods as identified by COVID. And then there is a flurry of tagline and merchandising just for hats, mugs, and so on. In fact, we're going to see many are for class 25. And then there is a few insult that we know after Brunetti, Jankover's Brunetti, and in Retam, we can register. So the F word, COVID, and so on, bad gesture, and so on, they can be registered right now, even though also these are merchandising related. So these are for the term COVID. For coronavirus, you see even more just trademarks. A lot are for merchandising. A few for medical businesses. Then when we go 6 feet apart, the vast majority is for merchandising. And then social distancing, we have some medical businesses and actually legitimate businesses, a lot of stuff that is really, we don't even know why these is applied. And when we look at all these together cumulatively, again, we have all 30%, which is medical related, and the rest is not. Now, I'm interested to see how many of these will be granted or how many of these will die. But each of these categories have these issues. So medical businesses where COVID can be descriptive, and that's why we want in each application to see if there is a disclaimer, because of course COVID is the type of disease, with the coronavirus, COVID, SARS-2, and then that create the COVID-19. And so this is a descriptive term, if not generic. And so what are these companies claiming? The logo, the combination of words, they are disclaiming that COVID is not part of the application, the same for the word coronavirus. When it's an unrelated business, we know that arbitrary terms can be protected, and so that could actually lead to protection for completely unrelated goods and services. In the merchandising world, a lot of these are going just to be rejected. Even just looking at the specimen, many are just T-shirts. And this clearly the failure to function doctrine will kick in. Even in some of these non-final office action, we already see these doctrine be used. And very similar for offensive terms. It's not that they will not be registered because they're offensive, but they will not be registered because they're not marks. They're not really functioning as trademarks. Then, interestingly, again, the basis for filing, and the vast majority of these are based on 1B, so intent to use, known actual use. And so here again, when we break them down, we see that not even a third of these marks are actually in use, and those who are in use tend to be primarily those are actually used for medical related issues. Coronavirus similar, 6 feet apart, social distancing, and here you see, again, the cumulative again. Then we're looking by class, so the 45 classes by the international in this classification. The classes that are the highest use are, of course, class 5, because this is where the medical related goods are. Class 9, class 10, and then of course the class that has the most is class 25, so for clothing primarily, for a lot for the merchandising. So here you have some charts, and so based on class you see how high the class 25 is again by each of these, and when we look at the cumulative, again, you see how high the class 25 is versus. And what's interesting is that there are the vast majority of these are applied for one class, very often is class 25. Some apply for 2 classes, and then, all the way down to 6 classes is the maximum. And why that's relevant? Because there is more fees, but the more classes one applicant apply, the less percentage-wise. So the first fees is 225 or 275. Per class, but after there is a rebate and more classes applied for. And so this is this slides for that. Now, what is also interesting is the timing. And when we look at, we have been dividing in the publication. I'm just going to do monthly, but here we actually broke it down by bi-weekly, so by twice a month period, and very expected, quite expected. We see the peak, going through the month of March and the month of April. Basically, end of March, April, May is when we see the peak, and now a lot of these are still applied, but on a much less number. This coronavirus, so this is COVID-related trademark, this coronavirus, this is 6 feet apart. Now, some things also, the trend comes, is a big wave, and some of the things are ancillary, they come after. Social distancing is coming after. Now that everybody's out, we're no longer in shelter in place. We have to social distance, so there is more things coming out with social distance. I've been looking at the word mask as well, for example, and there's been more recent activity, even though this is a mark that is a bit more spread throughout many years. And this is again the cumulative. When you look at accumulation, you see how that curve works. And the type of applicants, as I mentioned before, so in the medical field, most are corporation. But then when you go into the merchandising, into the unrelated businesses, the vast majority is really individuals. You can see how many. And this is by far the biggest. So individual who just file without even the help of a lawyer. And these are marks that are application that I would say 90% will be rejected, even just looking how the specimen has been filed. These are failure to function, clear cause for rejection. And limited liability company, again, very small companies. And so here you see how that's broken down as well. And so this is the cumulative. And so when we look at that a bit in context, we see, it makes quite big sense that there is a lot of merchandising, a lot of unrelated businesses, and a lot of individuals. And, again, there's been a rush. And of course, no surprise, there is a lot of these statistically have been based on intent to use, non-actual use. Again, quite predictably, we see a lot of these are for clothing and for business that are really known, relevant business in the respect to the word. It's a big sensation word. So what I've been interested on is, again, this is a big, I call it the trademark pandemic, is the biggest ever. And I, in addition to these 4 words I dissected for you, I've been looking at the word mask. And so historically, there are over 2,200 words, application, and you can break them down by month or by year. So broken down by year, you see, on average 150 and so on, but just in 2020, as of now, almost 600. Immunity, similar, a big boom. Antibodies is a word that is a bit more technical, is very difficult, it's not that attractive to go around with a hat and with written up on antibodies. So that is a bit more consistent, but quarantine, and interesting to see quarantine and quarantini as well. We have application for that, for drinks. Shelter in place, pandemic, just even the word pandemic has been booming in this application, and epidemic. And what's interesting, I tried also to compare with other, this is probably COVID-19 is one of the biggest events in our lifetime, but there have been other big events in our lifetime. 9/11, at least in my lifetime, is probably still the most shocking things that happened on American soil while I was on American soil. And, we have only 57 application, and the test tells you everything that dies as well, not just the live marks. And war on terror, war in Iraq, not that many. Osama bin Laden, looking at the word Osama, 30 kill Osama bin Laden and similar. Katrina, the Hurricane Katrina is also one of the major catastrophes of our, past 20 years, 90 application. Then I started looking at other pandemics. So HIV, there is no, if I try to key in the word AIDS, I can't get anything that has only AIDS, as I can get over 2,000 but result, but is with the word aid, so related to health, aid, and so it's not really representative. But if we key in HIV, we can find 229 results. Ebola, bird flu, I tried SARS, the first SARS, and MERS. There is no, MERS is maybe 2, and SARS, very difficult. Again, the strings don't pick up SARS. There is SAR, S-A-R, mixed with a lot of others. So it's really, there is no comparison whatsoever. Then I also look at Black Lives Matter, the current, of course, very important movement, both as L-Out and BLM. And just in the past, few years, but mostly in the recent time, there have been 53 applications and 25 applications for BLM. But when you measure these numbers versus these numbers, I mean, forget mask is 500 this year, but many of these are basically tracking the historical, is mostly 2020. It's enormous. This is just like, it's been a rush to trademark everything under the sun for any type of goods and services often, and we wonder why. And it's a problem, and why it is a problem. So it's an explosion of trademarks, largely driven by individuals who are spending between $275 to $225 if it's already in use. But if it's intend to use 1B, they have then to file every 6 months, another $125 renewal up to 3 years. And then, so even though there is fees that these individuals spend, it's a trademark explosion, largely driven by individual and small businesses, mostly for merchandising and unrelated product. I call him the Covfefe effect. You might remember when Donald Trump tweeted the Covfefe instead of coverage, and then deleted that tweet. That was rushed a big sensation on Twitter for a bit. And then there was a rush to file application for the mark Covfefe. And there were, as of today, there are 44 records found. But you can see, because mostly were, again, merchandising hats and mugs or stuff like that, that was largely found not to be functioning as a mark. And so many of these were either rejected or there was no response to the first non-final office action, and then that became final. But so out of 44, there are 5 that are live now. But every single entry does require an actual examiner to open the file and looking at the documents and send an office action. And that office action has to be justified, and that individual has to click and add documents to justify their action. And because the PTO cannot be accused of being biases, all the applications are randomly assigned to trademark examiners, so then the same might not get any other COVID-related application, because at this point it would actually be very time effective to be able to reject many of these on the same basis, because they are basically doing the same thing, trying to apply for COVID-related tagline for unrelated goods and services without sound specimens. But no, every single one might be assigned to a different examiner that have to restudy the case and send another email with attached reasoning and attached evidence. And I've been digging into a lot of these files, and certainly there is a letter, there is attachment, and so there is time invested in things that are going to be rejected. And why is that a problem beyond the fact that there is a lot of activity? So certainly the USPTO is getting fees, but this is the 2019 USPTO financial report without all this frenzy of application from COVID. And you can see that the revenues that the PTO obtaining trademarks are actually less than the expenditure that the PTO is spending in trademark. And when you look at the amount of money that the PTO enters, so the revenues with application fees is actually less than the cost of the applications. So that brings not just we have a cost on the lexicon. We see, a lot of this stuff can, a lot of these applications can be abusive. They can lead to trademark that should not be issued. But the reality is, even now, the PTO issue more or less 50% as compared of the application that we receive. And clearly they're losing money already. And perhaps there is an intention to say, everybody should be able to file a trademark. But the reality is we are seeing an excessive amount of application that cost the system, not just the potential lexicon, the potential claim of descriptive terms, of terms that we probably shouldn't even allocate as marks on a non-trademark function, but also there is a cost on the system. My personal reform is you just double the fees. You at least double the fees, but there is a pending proposal, and attorneys associations are very opposed to it. And there is some value in it, perhaps, small legitimate businesses, why should they pay more because so many others apply for things that they should not apply for? Maybe the PTO should be clearer in the PTO website about what should be and what's a specimen. But the PTO is quite clear, if I would say. There is a lot of instruction how in March should be filed. And still, we see a lot of these, and we have not yet a technology-related artificial intelligence or other way to be able to do the first action, office action, at least that could be completely automatic. Through software reading this document and figuring out if they are sufficient, and then sending out this office action automatically. So at least we don't have a human who has to open all these files, because as you see now, they are expensive and they are a cost on taxpayers' money, and a cost on these individuals who apply for things, hoping to get them, perhaps because they think they should get a mark, but in reality, they will not get a mark. They are going to spend $200 plus, maybe the fees for an attorney that they don't need to spend, and then maybe some extra money for filing extension for 1B, and still they're spending some fees that they could use for the business. And they don't need to have a registered trademark because they still would have unfair competition rights. So, with that, the conclusion is really there is cost with these. And here is, stay safe. There is, something around 500 applications, but just this year, there is 39 records for Let's Stay Safe Together. These are all trademark applications, many of these again for hat and mugs and merchandising goods. And so, with that, I thank you, and I look forward to your comments and, suggestions how this research could be of use. But we are very interested in, this is like a tsunami of applications. I think the data itself is really what's the most interesting thing. It's never happened before like that. And even with the big event in history before. And so many thanks.
Thank you, Irene. We've got a question here about, well, here, I'll just read the question. You seem to be opposed to trademark applicants capitalizing on current events by claiming trademark rights in popular terms that are not used descriptively, but are used with goods and services that are unrelated to the terms themselves. So for example, social distancing for restaurant services, COVID for computer software. Why should we not allow these types of trademark applications?
I am not opposed to those two examples. I actually think those two examples are very good. Social distancing for restaurant services is actually a very, I would say, arbitrary term to describe an existing activity. I think when you look at, if you look at the breakdown, here I would clearly put those in the orange. The problem, and you see, the medical businesses and the unrelated businesses, so computer software, so existing businesses that want to identify goods and services, it's absolutely fine. Where we have a lot of problems is the, social distancing hat, social distancing phone case. These are non-used as trademarks. These are used as decorative things. They are used as taglines or sentences that are, slap on any potential good, or but they really are not indicative of a product that is either a good or a service or economic activity. So they clog the system and they will be rejected. And so because they will be rejected, they are a waste of money for the people who apply. You can say clear, let them waste their money. I don't have a problem with that. But the problem is you can see that waste of their money is actually a waste of public money in the examination for goods and services that are not used, because there is no a good or a service. It's just a decorative element. And while Mercedes for a t-shirt, it's an affiliation of an existing businesses. So if somebody invented the COVID vaccine, then they could have, Pfizer or whatever, they could have also the COVID vaccine mug and t-shirt, because that would still be part of their goods and services affiliation, merchandising product, just to use a fancy term on a product that is really non-indicative. There is no economic activity, but slapping that on a t-shirt, it's the problem, because the system will not issue it anyhow. And so you have a lot of time and effort from the beginning to the end. Now, people who apply, fine, but all the public money invested in examining something to reject it and spending mine and yours money to pay somebody to actually do this useless activity, that's a problem, I believe.
Another question, thank you. How did you compile your statistics? Did you use an API from the USPTO database or a manual process?
So we have done, I have a team of 5 research assistants and myself. So we use the tests, and then we open every single application. We divide them by months, first by year and by months. And so to have data sets that are manageable, and then every single one is open, checked through the TDSR, type 1.1, and I have a major big Excel sheet for each of these marks divided by months that categorize each of those. And then we cross-check in multiple ways to make sure there is no mistakes. We find a few mistakes in the data set of the test actually, but we have used the same mistakes. So we are now, like this, under the coronavirus list, there is some COVID and COVAX that are supposed to be in the COVID sheet, but we left them under the coronavirus because that's how the USPTO has categorized them. Yes. No, we everything. So it is a very intensive time, but I think that's the only way you can actually do a reliable data set.
Yeah. Okay, we've got time for just one last question, and we actually do have more questions. Basically, the question is, what's a solution to reduce trademark applications made most likely by people who don't know they're applying for a mark that is not indicative of a source of goods in order to reduce the public costs? Do you have any solutions in mind?
Well, I think so. That's exactly where I'm very interested. So partially a bit more higher fees deterrence would not be a bad idea, even though, not major, just even $100 more, at least to come even, at least, you allow it, but we can cover the cost. You see, now we have 191 million that come in and to one. So it's basically, there is a third extra expenses. So increase a bit the fees, increase the fees more of the big ones, so the bigger businesses, because they also do that. But then I think one of the things that could be done is to really start to do a bit more advertise, so more into the PTO office, where before being able to apply for a mark, every applicant should necessarily watch a tutorial in which the PTO clearly say, these things will not be registered because, an example, t-shirt and that, if you use that. So if you have a mandatory tutorial that you have to take that is well built, then the applicant say, oh, wait a minute, this is not really a specimen, this is not in my tag, this is, clear ornamental, oh, and so they will understand that the likelihood is lower. And they might still try, but at that point, you have a bit higher fees that at least cover your costs. And so I think a bit more upfront in terms of, you don't even have to have a lawyer to do that. You can really create now good tutorial where you tell the applicants. Now in Europe, they care less about that. We want to have a registry which is cleaner, which I think is important when you look at the 100,000 of mark, also because weak rights gives So weak marks can still give high rights and big rights when are in the hands of bullies, because then if there is somebody getting the registration for that, then other people might get a cease and desist letter saying, I have the right to, you have to buy a license from me, and then and then the whole thing starts again in terms of licensing fees that they shouldn't. And again, often these marks are not needed, particularly for small businesses. They can operate under these marks and have unfair competition protection with no problem. So I think we should always consider that. Now, I understand that sometimes the attorneys, and I was one, don't have the incentive to say, well, you don't need that, so I don't get my fees. But I think it's the ethical thing to do, to say, well, you don't need that, particularly if you have a small businesses. Many really don't have any interstate commerce. They say you have a website and that's enough as interstate commerce, particularly when you have intent to use at that stage. So I think a bit more education up front nowadays. We have so many ways to do it. Or we should figure out a way through artificial intelligence to sift through this application and just send out this notification, say, well, get the $270 in, get the automatic machine who sends out stuff, and then let's wait, and some of these things will just die automatically. But right now we are spending more than we are earning with this application. So I'm a trademark professor, so I think this is bad. It's bad for public policy. It's bad for lexicon scarcity, but it's also bad for the pocket of the government. And so I think that's another extra reason why we should not allow that.